And when I was giving the reasons for the court, I said it is relevant to look to what the law on this subject is. What the highest court in Australia has said is not clear in its application to this particular case, but where there is an uncertainty or there is a gap in the law, we are entitled to look outside the law of Australia to international human rights law. It is not part of our law, but the judges, we the judges, can bring this aspect into our law as a part of the law of Australia. And so that was pure Bangalore. That was the application of the Bangalore principles. The case is a reported case. It's Grabbage against Grace Brothers Limited, and it is often referred to in Australia. Now, 3 years later, I'm talking about 1992 in Australia, one of the biggest cases ever to come before the High Court of Australia came before the court, and the case is called Mabo versus Queensland. Every Australian law student and judge and lawyer knows it. And this is the case about the entitlement of the Aboriginal people in Australia to have recognition of their native title to land. That had not been recognised in colonial times because it had been thought that the Aboriginal people in Australia were purely nomadic, that they didn't have law, they didn't have organised society, they didn't have writing, they didn't have towns, they were nomadic people, and therefore it was held we didn't have to recognise their native title. But in the Mabo case, the majority of the High Court of Australia said that where there is a gap in the law, the court can look to international human rights law, and when you do so, the one rule that is absolutely clear in international human rights law is that you cannot deny people their rights by reference to their race, to their ethnicity, to their nationality, to their skin colour. It can't be done. It's contrary to the universal principles of human rights. And so in the Mabo decision, the High Court of Australia used international principle to give the basis for re-expressing the common law of Australia and holding that the Aboriginal people were indeed entitled to recognition of their native title unless there had been freehold grants that prevented that. Any unattributed Crown land throughout the whole continent could be the subject of native title. And that has gone on to work a revolution in Australian law, and I believe that the Mabo case applied the Bangalore principles and brought in international law into what was otherwise a rather barren area of the law in Australia. Now, since that time, there has been something of a controversy in Australia. Some judges do not like the Bangalore principles. They think it is a heresy and it is not a proper legal principle, even though it was applied by the majority of the High Court of Australia in the Mabo case. And sometimes, of course, the law is clear and there is no ambiguity, or there is no space, and there is no opportunity for a judge to bring international law into operation. One such case involved this country. It was a case of B against the Minister for Immigration. It was a refugee case. and it was a case concerning children who had come to Australia without a visa, and they were put into detention. And they argued that in such a case, because Australia had signed the decision in the Convention on the Rights of the Child, the requirement of Australian law that the children have to automatically be sent to detention was contrary to the Convention on the Rights of the Child. And that was a very persuasive argument for me. But the problem was, when you looked at the Act, it had very clear provisions for the detention of children. And those provisions were clearly within the power under the Constitution to make laws with respect to aliens and with respect to external affairs. And therefore there was no ambiguity, and the objection of the government had to be accepted. So the Bangalore principles will take you so far, but they will not take you into a position that you can disagree with a clearly constitutional and unambiguous law. I heard a lot of talk at this conference yesterday, which I can semi-understand, about whether human rights are better protected in India or in Pakistan. And I want to tell you two areas where I think that you can learn from overseas countries. First of all, you may have seen in the newspaper that last week in Malaysia, a decision was made by the government of Malaysia to abolish the death penalty. Now, that is an example of an application by Malaysia of the second optional protocol principle of the International Covenant on Civil and Political Rights. And I think that is an area where this conference and Asma's energy and her law firm can take up the issue of universal human right to life and the principle which is going to be introduced into the law in Malaysia. And secondly, last month, a very important decision was made by the Supreme Court of India. The case is Jovin against the Union of India. It is a unanimous decision of a constitutional bench of the Supreme Court of India. And the case concerns section 377 of the Indian Penal Code. That section is the same as the section in the Pakistan criminal law. It's the same as the section in the criminal law of Bangladesh, the criminal law of Burma, Myanmar, the criminal law of Brunei, the criminal law of Malaya, the criminal law of Singapore. All of those countries have copied the Indian Penal Code, and all of them have section 377. And the Indian Supreme Court unanimously held that the provision for the penalisation of homosexual people, criminalising the consensual adult private acts, is completely contrary to the Indian constitutional principles of equality of citizenship and equal dignity of all sections of the community, and also the issue of privacy, the constitutional right to privacy. Now, I know that in Pakistan, the Supreme Court of Pakistan has made some very forward-looking principles about transgender persons, but not so far on the issue of gay people more generally. And it's important that a conference such as this, with leaders in the human rights field in Pakistan, should be aware that this is an area where a decision was reached only last month in the Supreme Court of India to strike down this decision. You'll remember that yesterday I said all of us in human rights have to get out of our comfort zone. If we're in the areas we're comfortable with, then that's fine. But you're not going to break any eggs. You're not going to push the Charter of Human Rights forward. And Asma, if she were here today, in the light of the decision in the Indian Supreme Court, would be saying, we in Pakistan have to look at that decision and to see if it provides an opportunity and a principle that can be pursued in this country as well. Human rights belong to everybody. And I see on the agenda of this conference today, there is a person who is speaking from the transgender community. And I think that is terrific. But what I'll be listening out for is whether there are people who are speaking up for the gay, lesbian, bisexual community, because they also are human beings with human rights. And you remember the first words of the Universal Declaration, all persons are free and equal in dignity and rights. All persons means all persons. Now finally, I'm going to tell you that I myself am gay. It's important I should tell you that, not to intrude a personal thing, but to make the point that gay people are not just hairdressers. Gay people are not just actors. Gay people are everywhere. You can take it from me, there are plenty of gay judges, there are gay advocates, there are gay diplomats, there are gay professors. They are everywhere, and they are human beings, and they are entitled to equal rights under the law. And it's very important. It's important that the legacy of Asma must not stand still. It must continue to expand and must be there for everybody, not just the selected few, but for everyone. And if Asma were here today, that is what she would say too.